Patents are most appropriate for the protection of new technologies, and technologies can cover a broad range of subjects, everything from machines like computers or automobiles or whatever, to any kind of life sciences type inventions, chemicals. If I had an idea that I thought was worth taking to market, I would talk to somebody who's familiar with the patent system to find out what can be done with it, because almost any form of idea can, with proper consideration, be cast in a form that is patentable. There are some things that can't, abstract ideas, but almost any application of an abstract idea, which comes out in a machine, a chemical, a process, is patentable. It just, again, you want the right kind of thinking beforehand in order to make sure that you've got protectable claims when the time comes.
One common mistake that entrepreneurs make when they're first starting out is that they're filing their first patent application and they try and not only protect what they've invented and actually made, but they try and extend their patent further to all kinds of applications that they're guessing at, and guessing at broad applications. What can happen is that if they guess, unfortunately correctly, when they actually make that new and inventive application later, they could be shot in the foot by their first application, which they've hinted at this application. And patent offices around the world may deem their second application to be obvious or not novel in light of the first.
One of the biggest mistakes I see entrepreneurs make, especially people who are kind of going through for the first time, is trying to do too much by themselves. Patent help can be very expensive, but it's extremely important to protect patent rights from the start, and that takes effort and time and specialized training. I have seen too many people, I think, try to write their own patent applications and file them, and it's really difficult years later to support some of those patent applications. So most of us in the profession are used to helping people at the starting stages and are used to giving guidance and even helping out at the beginning to get you where you need to be from the start. But it's very important to talk to somebody and get the guidance early on so that 5-10 years from now, when you're a going concern and you've had your investment, you've got the applications and the patents that you want. Some of the dangers that I've seen are that entrepreneurs, who tend to be very bright and capable individuals, try to take too much on themselves in the early stages. And then later on, once the idea is kind of up and running and they're beginning to attract initial rounds of investment, it can lead to problems because the people who are making the investment want very carefully laid IP plans and implementations, and sometimes you're left scrambling trying to show them that the invention has actually been protected properly. We do deal with this quite a lot, and it can be a real problem, and it usually happens at a time when money is very tight, and unraveling the problems can be much more expensive and difficult than having prevented them in the first place.
The best piece of advice I could give an entrepreneur starting out is, first of all, many know that they shouldn't be disclosing their technology without first filing a patent application. However, if it's absolutely necessary, in some case it is, because some of these entrepreneurs are academics as well and they need to publish. So if you have to disclose, then do it under a non-disclosure agreement, but obviously the best course is to file a patent application before you disclose your invention to anybody.
Yeah, timing is very important for entrepreneurs in the invention or the protection of ideas, because the idea of the patent system is to protect ideas that are already not known to the public. So somebody that goes out, gets a good idea, but goes out and talks to investors, even to competitors, to somebody to help them develop the idea, may have placed the invention in the hands of the public. And on a worldwide standard, that's probably not patentable anymore, so extremely valuable rights can be lost.
After you file a patent application, you are protected against prior art from the date of filing. Therefore, after that, you can talk to investors and you can talk to anybody else about it. and you will be protected as of the original filing date. One thing to remember, though, is that patents don't actually issue usually for at least 5 years. After that date, you will actually be able to enforce it.